Hello, my name is Colin Browning, and my final presentation is going to be about the First Amendment and the freedom of speech in the digital age. So, starting off, an introduction. The First Amendment is protecting free speech. So, the First Amendment means that the government cannot make laws that restrict what people can say and express themselves, allowing individuals to speak their minds without fear of government censorship. Although types of speech like obscenity, defamation, and the incitement to violence are not protected. Now, the growth of technology and social media in the last 20 years has been very prevalent and has changed the landscape for what free speech is and what it can be. It becomes more and more difficult to involve the public in debating what values the First Amendment was meant to serve and if these values are being upheld today. A lot of principles we took for granted about the First Amendment may not apply given the platforms of communication that are available to us today. Historical context. The original intent of the First Amendment was to prevent the government from interfering with individuals' fundamental freedoms, including the freedom of religion, speech, press, assembly, and the right to petition the government. The interpretation of the First Amendment has varied a lot through the years. I will cite a specific court case. The court case of Schenck versus the United States in 1919 was a landmark decision that created a threshold for determining when the government can limit free speech. A man named Charles Schenck mailed letters during World War I encouraging citizens to disobey the military draft so they could avoid going overseas to fight in the war. The Supreme Court upheld the ruling, creating the clear and present danger test. The mailing of these letters were deemed illegal due to the interference with the war efforts. The case is still relevant today as an example of how the justice system evaluates and constitutional constitutionality of federal laws. Another case, Brandenburg v. Ohio in 1969. Um, a man named Clarence Brandenburg, he was a KKK leader, and he gave a speech at a rally insinuating violence and the portrayal of derogatory and racial slurs. This was seen by the state of Ohio as an advocacy for violence. When brought to the Supreme Court, it was ruled in favor of Brandenburg 8-0, being held that the government cannot punish inflammatory speech if it is directed at inciting or producing imminent lawless action, and they decided that this wasn't directed at any certain derogatory or lawlessness. Modern challenges. So, social media has provided an accessible platform for individuals to express their opinions to a global audience without the fear of much backlash. Public, so it brings up the question: is social media private companies? Are they public forums? And so, if they are public forums, they would be able to be censored by the government. A public forum is a government-owned space where free speech is protected under the First Amendment. The government cannot restrict speech in these places. Brings up the question, are social media platforms public forums? Yes or no? Well, social media platforms are private companies and not government entities. It raises the question whether or not the First Amendment principles apply. So, here are some arguments supporting the public forum view. Prevalence of speech. Social media has become the primary venue for public discourse. When the First Amendment was first put into effect, a public forum was seen as a town hall or such things like of that nature. And now Twitter or Facebook can be seen as a modern day quote unquote town hall where people can converse their opinions and disagreements. Um, Government interaction. Officials often use these platforms for public announcements, which can blur the line between private and public spaces. An example of this in Knight v. Trump in 2019, a court case ruled that President Trump violated the First Amendment by blocking users on Twitter, therefore treating his account like a public forum. And arguments against the public forum view. Private ownership. Platforms like Twitter and Facebook are private companies, not government actors, and are not bound by the First Amendment, so that means they are above it. Um, Content moderation rights. These companies have their own terms of service and the right to moderate content to protect against harmful speech, uh, such as misinformation or hate speech online. Um, Cases such as Packingham v. North Carolina in 2017 implemented regulations on social media within the state prohibiting registered sex offenders to have an account on any social media platforms where minors may be using the same social media platforms. Packingham argued that this ruling violated his First Amendment rights, but the court found that the law was a limitation on conduct and not a restriction of free speech during the appeal in order to keep the minors on certain social media websites safe and away from men like him. Controversies and balancing interests. So, what constitutes harmful content? Well, hate speech, i.e., targeting individuals based on race, religion, or identity, misinformation, false content such as election fraud claims or conspiracies, incitement, speech that encourages violence or illegal action, and harassment and bullying, content that causes psychological harm to another person. The free speech argument, concerns about overreach and regulating harmful posts or chat rooms online. So there are concerns about government overreach into the private sector, that is social media. Um, Overregulation risks suppressing legitimate dissent and controversial but important viewpoints. Technically, what is quote unquote harmful can be subjective and politicized. Advocates believe that false or harmful ideas can be countered by more speech, not censorship. There are two sides to the argument: protection from hate speech and misinformation, all while trying to prevent overreach, and the overall ethical challenges of trying to silence communities on social media. So, the conclusion. Understanding the importance of free speech is imperative to the social dynamic of the United States, which raises the question of my presentation. Should there be new constitutional interpretations to address digital platforms, or do current laws suffice? And that is all. Thank you so much for this final presentation, and hope you enjoyed it.